Hi and welcome back. I'm doing a series of forensic evaluation seminars. I'm an expert in forensics. I'm a psychiatric social worker with a background in psychology and law. Work in New York. I've done thousands of cases and I've been at it for about 20 years with a specialty in criminal mitigation for immigration defense lawyers. I think I'm the only person in the United States that does criminal mitigation as a specialty for immigration defense lawyers. Today we're going to be talking about a very specific area of forensic evaluation and consultation, which is competency hearing issues for immigration clients. One thing I'd say at the very outset is this. First, competency issues are rarely raised for immigration clients, even though it tends to be a ubiquitous issue. The second thing I'd say is that we learn in law school about competency almost always in the context of crim law, right? In the context of criminal defendants who are assessed to determine their level of competency for their ability to stand trial. The standard and context of a competency evaluation for someone in criminal court and the standard and competency concerns for someone in immigration court are completely different. So those are two things I really want to stress from the outset. First, that competency as a consideration for immigration court is rarely used, even though it's a great idea to consider. And second, it's not the competency we traditionally have been taught or think about in the context of criminal defendants for criminal court purposes. So I've sort of named this talk Competency Evaluation Immigration Proceedings, matter of MAM cases, because that's really the most famous case, MAM. Most people are aware of it. And what I'd like to do today is just give a general sense of the background issues, something about matter of MAM, the major psychiatric issues to consider, and related concerns for evaluation purposes. First, I'd just like to say, if you're interested in seeing what a forensic case looks like for immigration defense lawyers in competency situations, please feel free to email me. My goal is always, when I lecture, to integrate theory with practice. I've lectured to tens of thousands of lawyers throughout the United States, maybe 100,000 lawyers at this point. Predominantly immigration, criminal, and civil litigation lawyers. And it's important for the PowerPoint slides that I have in the presentation to be able to have practical use for lawyers who are practicing in the field. So please send me an email with your name and put in the subject line matter of MAM, so I'll know what the area is, because I give a lot of CLEs. And just tell me who you are, put your signature in the email so I know it's not spam, where you work as an attorney, and so on. And I will send you back a redacted copy. In other words, a competency hearing evaluation that has relevant information, which of course is redacted in the sense that the client's personal identifying information, date of birth, and so on, and other issues have been changed. Again, the idea here is to integrate theory with practice. Just generally tell you about myself. As I said, I'm a criminal mitigation specialist for immigration lawyers. I do a lot of VAWA cases, a lot of cases where spouses have been abandoned when they have a 2-year temporary green card. Obviously, a lot of deportation removal cases, waivers, asylum, particularly if there's a 1-year bar issue, U visas, detention cases. I often visit jail, especially ICE detention programs. I teach the Adam Walsh Act case for evaluations for immigration defense lawyers, and many other areas. I just want to plug shamelessly my book, Handbook of Mitigation in Criminal and Immigration Forensics, and the subtitle is Humanizing the Client Towards a Better Legal Outcome. This is the book. I hope you can see it. I have a specific chapter in the 7th edition, the 2021 edition, on competency evaluations in immigration defense. The subtitle to this book is Humanizing the Client Towards a Better Legal Outcome. And that's the core hope in all of my work, not just to get a clinical evaluation for a lawyer, whether it's a criminal lawyer or immigration defense lawyer, but to allow the lawyer to have a better sense of who the client is, to humanize the case so that once the client is humanized, we understand the client's background and issues, challenges, traumas, personal concerns, and so on. The adjudicator, whether it's someone at USCIS or an immigration judge or whoever, gains better insight into the client's judgment and decision, their background, their family, community attachments, and so on. That's the core idea behind forensics, to help educate lawyers so that they themselves can become better advocates. This is another book I have, and I think many lawyers would be interested. It's called Psychosocial Evaluations and Consultation in Civil Litigation. It's really for all lawyers, not just civil litigation lawyers. But one of the things this book has very clearly outlined is how to do a psychosocial evaluation. It's something we should have been taught in the first few weeks of law school. A client comes in your door. How do you talk to the client? How do you elicit information from the client? It's particularly important in competency cases where the client may indeed suffer trauma in their background. They may have psychiatric issues. They may have limited ability to self-advocate or explain their concerns, and so on. So this book explains how psychosocial evaluations are undertaken in a very practical way, but also some of the major challenges that occur when undertaking psychosocial evaluations, particularly in the context of forensics. I want to talk a little bit now about matter of MAM. It generally has a three-pronged test, and I just want to review it very quickly. First is the concern is, does the respondent in immigration court understand the nature and object of the proceedings? This is a very serious issue. Does the client understand the process, what's going on in court, the adjudication itself, and does the client understand the aim? That is, does the respondent understand the objectives of their attorney, of the judge, the government attorney, and so on? So does the client have a rational and factual understanding of the nature of the object of the proceedings? Second, can the respondent consult with the attorney or representative? That is, can the respondent assist? This is crucially important, and I want to give one or two extremely relevant examples. When I see a client, they come into my office, the first thing I ask are the most rudimentary questions. For example, I say, how can I help you? Many times a client will tell me that they have an asylum case and they've been referred by an attorney, but they don't actually have an asylum case, they have a cancellation or removal case. That tells me a lot about the client's ability to advocate and explain their case. Often I'll ask a client even after the matter has been cleared up, and I say, oh, you have a cancellation or removal case, and I will say, what is it? What kind of case is that? And clearly they know it's about immigration, but they have very little sense. For example, they'll say, oh, I've been here 10 years, so I can get a green card. Or they'll say, I entered the United States, no one saw me come in, but I have American children, and I just have to show that, it would be bad for their education if I have to return to Mexico, for example. Well, that tells me that they don't really have an understanding about the process or the object. And the third prong is reasonable opportunity to examine adverse evidence, present favorable evidence, and cross-examine government witnesses. We have to understand that, when we're in law school, you know that you're going to get all sorts of clients in all sorts of contexts for family cases and mortgage cases and, corporate clients and so on. And the client comes in, you work with the client, the person's normal, and, You try and understand their legal issues, provide counsel, and so on. That's not true with immigration clients. Many, many immigration clients we see have suffered trauma and severe challenges in their country of origin because of poverty, systemic corruption. Women have suffered misogyny, abuses of all sorts. And many clients have come from places where there's a lack of basic necessities. Many clients have abandoned their educations in grade 6, and it may not even be the equivalent of a grade 6 education. I ask clients, when they first come in, to tell me their names and to spell it. Very often clients cannot spell their own names without errors, or they cannot write their own names without errors. This tells me something fundamental about whether they have the ability to examine evidence, whether they have the ability to compare and contrast evidence between their lawyer and perhaps the other side, and whether they can reasonably answer questions. When I have clients, I work with them in a very clinical way, in the sense that I understand that they're fragile, perhaps vulnerable because of their experiences, and it allows me to consider ways to elicit information that helps me understand them. But, my office is not immigration court, where it could be very frightening, where they may feel very put upon and threatened. These may be people who've suffered terrible threats and harms and injuries in their past. And so these three prongs together from the matter of Mam case really reflect the concern that the clients we see may not have the wherewithal to, in fact, be able to reasonably go to immigration court and understand the process, understand the aims, understand the evidence, and perhaps not even be able to consult with their attorney in any kind of reasonable way. There are indicators of serious mental disorders that I just want to broadly allow immigration defense attorneys to know about. These indicators are red flags for me when I see clients, and they should be red flags for you as an attorney when you see clients in your office. The first is difficulty communicating thoughts completely or coherently. Can the client, just as I said, coherently explain themselves in a way that is smooth? In other words, is this a person who in a minute or two can basically explain what their issue is, or do they need 20 minutes and their thoughts are all over their place, their speech is all over the place, they become confused, almost disoriented? The second is perseveration. That means, is the client going over the same thing again and again without any clear reason? Third, is there overly simplistic or concrete thinking? For example, someone who has been the victim of harm in their country of origin because of abuse, are they able to give examples of the abuse? Are they able to give specifics? Can they flesh out the case? Or are they very, very concrete? They just say, I was sexually abused, I was physically abused. Well, that might be true, but unless the person can flesh out the issues, they are not going to be able to reasonably explain themselves and stand up for cross-examination in immigration court setting. Next, is the client presenting with words or actions that don't really seem to make sense, that it suggests that the person is experiencing hallucinations, an altered version of reality, and so on? Is the client in the moment? Is the client focused? If the client is not focused and they seem to be responding to outside stimuli, it's a red flag. Next, is there obvious memory impairment or poor ability to process information? This is crucial because the client is going to have to defend their assertions under cross-examination from the government attorney. You have to have considerable wherewithal to have short-term and long-term memory and the ability to process the information. I have to tell you, I'm cross-examined. I've been cross-examined God knows how many times over the last 2 decades in immigration court. And I can tell you as a professional, and I've been in college for like 12 years or something, the ability to remember issues and details from the case and bring them back specifically and related to clinical issues that the client presented regarding the trauma that is the underpinning for the asylum case that the client has petitioned for is not easy. How is the client with a grade 6 or grade 5 or grade 4 education going to be able to do it with these serious indicators? Next is, does the client seem in it and out of it, in it and out of it? In other words, does the client seem to be not able to focus in a way that suggests that the client is disoriented, that they're not fully awake, that they're not fully conscious, and so on? Just generally, does the client have a high level of distractibility, inattention, or confusion? Does the client sort of present ADHD-ish? And last, is the client very impressionistic? Does the client easily cower? Does the client easily defer to others? Is the client very docile? This is a huge problem for clients who have been the victims of abuse, particularly women who have suffered misogyny, physical, sexual, emotional, verbal, financial, other kinds of abuse. Because you need a client who's going to be able to explain not only the issues in detail in your office and maybe in my office so I can do an evaluation, but the client is going to be able to feel sufficiently comfortable, one hopes, to go to immigration court and explain it and then defend it when there's cross-examination or questions that are unexpected. If the client is very docile, the client may not be able to sufficiently speak for herself or himself. The other thing is some of these clients are, I use the word impressionistic. There's some clients I've seen in competency cases where you can almost convince the client of anything. And, you have the government attorney saying, maybe it was like this, maybe this happened, maybe you remember it incorrectly. Was this date really accurate? Was perhaps another person there? Is it possible you misremembered? And the client saying, well, yeah, it's possible. This is possible. That's possible. Some people, because of their mental health issues, the trauma they've suffered, are quite impressionistic. You don't want someone who's impressionistic. You want someone who's able to stay focused on their narrative. And it's not the client is changing or altering their story because they want to lie, obviously, but it's because they're easily influenced. And that's yet another indicator of serious mental illness that needs to be safeguarded against. And that's the next thing I want to talk about. That even if a respondent in immigration court has been pronounced mentally competent, procedural safeguards may be necessary to ensure a fair hearing in immigration court if, for example, a respondent has a significant history of mental illness or is experiencing an acute aggravation of mental illness at that time. It's also possible that the client's condition has changed. In the medical world, conditions change all the time. You can be acute, you can be chronic, all sorts of things can happen. A medical condition can become exacerbated. It can become stable for weeks, months, or years. Has this client's condition changed significantly that would have us concerned for competency? Now, this is huge for immigration cases, not so much for criminal cases. Why? Well, if you're in court, just for example, again, going for it's an asylum case, bringing up the memories of the trauma, physical, sexual, emotional abuse, persecution, human rights violations, whatever, itself triggers very negative memories. That in itself may change significantly the abilities of the person's ability, the respondent's ability to be competent to answer questions and assist the lawyer and so on in immigration court. Next, I want to speak about something very crucial, which is diagnosed incompetent. A respondent may have the ability to consent to representation and even to assist in his defense, even with a serious psychiatric illness. There are clearly people who have schizophrenia, bipolar disorder. They may have suffered horrible trauma in their country of origin for whatever reason, it doesn't mean that they're not competent. It may, in fact, find that the person has, over the months or years, been able to adequately contend with their trauma and that they are, in fact, competent. Mental impairments do not necessarily preclude meaningful participation in proceedings. And it's similar to anybody who has a medical issue who can be quite competent, right? I mean, you can have a very serious medical issue and you can go to immigration court or criminal court or family court or, any kind of court. It doesn't mean that you are precluded from participating because of a medical illness, even if it's quite serious. The takeaway from this is that it's important not to be condescending or presumptuous about the ability or limitations of persons with mental health issues. The other thing is, a person may not be psychotic and yet they may not be competent. This is hugely important. A lot of immigration defense lawyers think, well, the person has to be schizophrenic with suffering hallucinations or delusions, or the person must be acutely psychotic with bipolar disorder at the time in order to be incompetent to stand for immigration court proceedings. That's not true. A person may not be psychotic but still not be competent. I just want to give you a few examples. The first and most obvious is cognitive deficits or limitations. A person may be elderly and they may have severe cognitive deficits due to dementia, the most common of which is Alzheimer's disease. And they may have very serious limitations in processing information and memory and organizing their thoughts and so on. It doesn't mean the person's hallucinating. It doesn't mean the person has delusions. They're not psychotic. Another very obvious example is children. You may get a 10, 12-year-old child who has very important information about an immigration case. The child's not psychotic. Doesn't mean the child is competent to provide feedback regarding their case or to go to immigration court. Another very obvious example is someone with an intellectual disability. There are 200, 300, 400 reasons for intellectual disabilities, mostly rooted in genetic abnormalities. A person can have an intellectual disability. It doesn't mean that they're psychotic. So a person does not necessarily have to be psychotic, and yet they can still not be competent. Some clients also become quite bewildered about the whole immigration court thing and immigration and courts and law in general. Some clients just don't understand the statute or law. It's too overly complicated. It's nuanced. Clients have maybe a grade 6, grade 5, grade 4 education. Clients may view their behavior as normative. I see a lot of white-collar cases, and these are clients who are very educated sometimes, and yet they are unable to understand the white-collar statute that's applicable to them in federal law because it's very complicated. They need a white-collar criminal defense lawyer to carefully explain it. I have white-collar defendants who I've seen where they say, what I did seems to be common practice among colleagues. So there are different reasons why clients become bewildered, and sometimes there's also a complex set of facts. All these things are all the more true for our immigration clients who've come from places where they've suffered trauma and challenges and so on. They may not understand the statute. They may, be unable to properly bring together all the facts of their case in a way that misses not only details but a broader narrative. Sometimes it's necessary, and I do this a lot, to consider parallel histories. Parallel histories, when you take a history, a clinical history, it's of an individual. A parallel history occurs when you ask perhaps a close family member or friend to give a history of the client so that you have additional information or parallel information. Obviously, this is extremely important for someone who's not competent. If the person is not going to give a fair or accurate or informed or detailed history, my personal preference is to go to the family member first. And I'll just give you a very, very serious case I had in detention center in Batavia, New York, just east of Buffalo. The client was flagrantly psychotic and had a long history of psychosis. And I spoke to the mom first. And she was very helpful, the mom and stepdad, and she was very helpful in giving information about the client's challenges with his mental health issues and his inability to provide for his own care and keep a job and so on. I went to see the client in Batavia, New York. I got almost nothing from this client. This client was being medicated. He had been medicated with antipsychotic medication for about at least 10 years. There was nothing the client said that was particularly coherent or helpful. And the client, was very engaging and wanted to talk to me and understood something about the case. But parallel histories in competency cases are often crucial. Sometimes clients have a history of documentation. This client in Batavia, New York, had about a 10-year history or 15-year history of psychiatrists evaluating him from time to time and prescribing medication. And so the documentation was extremely helpful. Clients that are coming, for example, from a place where psychiatric care was not available because it was anathema to their cultural background, or psychiatric issues were stigmatized in their country of origin, will most likely have no documentation about their experiences and how they contended with their mental health issues. And you're usually starting from scratch with those clients, and therefore it's all the more important to get a parallel history with family members. It's often helpful in competency cases to look at the course of the illness, the stages when there's ups and there's downs and so on. Some issues tend to worsen over time, such as schizophrenia. Some mental health issues tend to find a sort of even keel over time. Some clients are helped, of course, through medication and psychotherapy and so on. The reality is that there's not a lot of predictability with mental illness. It's not a popular thing to say, but there's not a lot of predictability, even for people who are compliant with psychiatric care. Triggers often, such as major life stressors, can precipitate periods of acute stress and acute illness. For those clients, coherence may be tenuous. Clients may lie about their mental illness due to shame or a deep desire to look healthy to outsiders and so on. There's a general rule in mental health. You don't trust your clients because of these issues. You have to speak to them in a way that's very caring and sensitive to these issues so that they're able to open up because they're so reluctant to speak about their issues. One of the reasons psychotherapy takes years and years for some people is that, many of these issues are very painful or embarrassing to speak about, and it's important for the client to develop a trusting working relationship with the therapist in order for the client to be honest with the therapist and in order for the client to be honest with himself or herself. There are core questions that I consider, and I have them on PowerPoint slides that I'd be happy to share them with you. And I'll just name them very quickly. They're not that many, but they're crucial. First, can you tell me your name? Where are we and what is the date? Why are you in detention if the client's in detention, and many of them are? Do you know who I am? Do you want me to help you stay in the United States? Can I help you in immigration court? How might I be able to help you? Can you help explain and prepare evidence in your case? It's a very serious, broad question. Can you answer questions in cross-examination? I'm not saying that as a lawyer, obviously. I'm saying that as someone who's taking a forensic evaluation, wanting to know how well the client can understand and answer basic questions and adhere to them. I ask about the attorney. I say, do you know who is opposing you in this case and why? What is the immigration judge role? If the client says the immigration judge's role is to grant me a green card, that's not the role of the immigration judge. The immigration judge is there as a fact finder, obviously. What could happen to you if you do not win your case? What are the consequences? If the client says, well, if I don't win my case, I can go back to the judge next year. Or if the client says, well, if I don't win my case, I think I can stay in the United States because I'm getting asylum. The client has to have an understanding about process and outcome and consequences. How will you care for yourself if you must leave the United States? If this is a client who has a serious mental illness, what will occur? I had a great competency case where the client was actually deported once or maybe even twice. I can't remember. The client ended up, he was deported to Guyana, his country of origin, and the client slept on the streets for many, many months. He was harmed and abused and taken advantage of until he returned to the United States. Why? Because the client had very serious psychiatric issues. The client did not have a capacity to self-care. The client couldn't find a hostel or a room to rent. The client could not find basic employment. The client couldn't go to a church or religious center for charitable donations and so on. This is a client who could not care for himself. So these issues are very important to consider. There's a lot of bias and prejudice against mental illness. There are a lot of false assumptions. There's a lot of fear, anger, hostility. Sometimes there's a presumption by government that the client is lying if they have a mental illness because they just want a benefit such as a green card. All the more reason to humanize the client, all the more reason to destigmatize the client's mental illness, but also to consider the client's specific cultural and family and psychosocial background that may help illuminate some of these issues. I sometimes talk about the purpose of mitigation, which is my specialty, in other CLEs that I do, especially for criminal mitigation for immigration defense lawyers, for crimes, waiver cases and so on. But it's important here as well. It's important, the purposes of mitigation are, it's to humanize the client through a sympathetic narrative with consideration for the competency and mental health issues, to induce empathy into the reader, document the client's life history, contextualize the client's conduct, stress if there's family connections, physical, psychological, emotional, financial that may be relevant to the competency case, illustrate the client's community educational ties. Is this a client, for example, that has zero community educational employment ties because of their mental illness? Is this a client, just as an example, who is so incredibly isolated and lonely because of these issues, and his loneliness and isolation is reflected in his lack of community contact? If this client has done wrong in one context or another, can this client really express remorse and regret? And if the client can't express contrition, is it because this client has a mental illness? They don't really have sufficient psychological insight or understanding about their judgment or behavior. It's very important in these cases that professional judgment and professional expression can replace self-expression. In other words, if the client cannot adequately express their issues, they need a mental health professional to explore them for them. Just like clients in immigration cases, which are far from simple, need professional counsel. They need immigration defense lawyers to explain their legal options, to counsel them, to explain the law. USCIS or immigration court can be extremely complex to navigate, to counsel them, to tell them their options. You get a lawyer because the law is complicated. Their mental health issues are complicated too. They can't, sufficiently explain it themselves, and they need an advocate or someone to explain it. So the competency report that I write, it's not just a mental health report. It explains about who they are. It disabuses the government or the adjudicator, whoever it is, of bias or prejudice. And, it's almost a consultation tool to help provide a larger sense about the individual's functioning and ability to get along in the world, and certainly in the context of immigration court. So clients who most benefit are clearly those who have mental health problems, and particularly serious mental health problems. The clients who won't talk about their psychological issues, the clients who've suffered overwhelming traumas and abuses, often in childhood, but perhaps in adulthood as well. Those clients who have poor language skills, poor communication skills, they're not adaptive, they have poor self-care skills. They may have poor executive functioning skills, meaning they're very disorganized, they can't put things in a way in their lives that help them function from day to day. Some of these clients may have a deep fear of authority. I'll give you this great example. I used to see cases from West Africa, people who had suffered from soldiers in West Africa that came to the United States, and they were terribly scared of anybody in a uniform here, including like people in a uniform in court, or an NYPD officer, or even someone, at a traffic light, a traffic cop. The traffic cop doesn't care about the client crossing the street. The traffic cop has no animus, no thought about the client. But the client seeing this police uniform has these memories triggered from his life in West Africa, and it results in a fear of authority. Sometimes, and this is very, very important to understand, sometimes these evaluations are done just for case consultative reasons. I'll give you a really good example. I had a client who was twice arrested, I believe, while intoxicated for being assaultive against his wife. There were 2 children in the home. The entire family came, I believe, on valid visas, and they overstayed their visas. They had no status here. This was about 2 years ago. And the client was arrested, and he was being held about an hour north of New York. And the lawyer, the clients have no case, and the lawyer smartly thought, well, maybe this is a matter of mam issue. Maybe this is a competency case. This client has twice been arrested. Maybe the client has a mental health issue that's just emerging now. The client was in his mid-30s. The client had been drinking. Maybe the client's drinking to self-medicate against a psychotic disorder, who knows what. So I went to see the client, and it turns out the client was completely competent, completely clear-headed. But, when you do a history, you always do a general history to get some background information. I had seen his wife earlier before seeing the client, and it turned out the client talked at length about one of the main issues prior to coming to the United States was that they were living in a very rural area of Trinidad, and there were these gangs that were very, very threatening, with shooting guns and stealing and being quite violent and aggressive. And it wasn't just impinging on their quality of life. This was life-threatening, not only to the client and his wife, but also to their children, obviously. The police were of no help. They couldn't do anything. When I interviewed the client, it was clear to me that although there was no competency issue, there may well be an asylum issue. So it's something for immigration lawyers to understand, and some do that. Sometimes getting a general evaluation when you're not sure about which direction to go in or what the issues are can yield, through the psychosocial clinical evaluation, all sorts of background details that may help the lawyer become better informed about the client's case. I want to talk a little bit now about psychiatric issues. Obviously, the main psychiatric issues that one concerns these kinds of evaluations are psychosis. Psychosis means out of touch with reality, and there are 2 big areas. One is hallucinations, which are false perceptions, and the second are delusions, which are false beliefs. A false perception has to do with, taste and sight and hearing and so on. If I'm walking down the street and I hear my name being called, I turn around and nobody's there, and this happens repeatedly, that's an auditory hallucination. If I'm hearing a voice and the voice says, "Mark, you're terrible," that's an auditory hallucination that's derogatory. If the hallucination says, "To hurt someone, go hurt that woman at the corner. That's a command auditory hallucination. Psychosis is very central, and it occurs in different kinds of mental health issues and categories, but hallucinations and delusions are the most concerning. This is the difference. Hallucinations, you can only have 5 kinds of hallucinations. They tend to be very similar because you only have 5 kinds of perceptions. Delusions are false beliefs, and it can encompass a very wide array of beliefs and thinking that can be very systemic. In other words, it can inform how the person understands themselves and understands the world, and as a result, they function in a particular way because of the delusions. The most well-known mental health disorder with psychosis is schizophrenia, but as I said, it pops up in a bunch of different places. Many of our clients also obviously have PTSD, something very, very important to consider. It's very common to see PTSD with clients from Central and South America and other countries that I see for immigration evaluations because of what I said before. People have experienced years of poverty, years of government corruption, police ineptitude. There's misogyny. Women have suffered physical, emotional abuses. Clients have suffered years of unemployment. There may be systemic alcohol and drug problems in the community, all sorts of things. Environmental problems even. For example, we see this in Haiti, where there have been having, unfortunately, decades of natural disasters that have been fundamentally harmful to individuals and families and communities. Some clients have mood disorders such as depression. And we think of depression, we think of people being sad, and it's really a simplistic way to understand depression. Depression is a very, very serious issue. It can encompass suicidality, a chronic inability to get along in your life in any meaningful way, to function, to have motivation, cause very, very detrimental sleeping problems, eating problems, all sorts of issues that fundamentally affect the person's life. There are all sorts of disorders that, a person may think about in a way that seems like, well, can't this person still function? Can't they still answer their questions? Couldn't this person still go to court for a few hours? It's, such an important issue, the court proceeding. Can't they just get it together? And the answer is no, they cannot get it together. They don't have the ability, and this is particularly important, as I said again, for individuals who have perhaps only a grade 6 education, or people who've been, the victims of, emotional or psychological or verbal abuse, where they've been demeaned and degraded for years. I also just want to mention, just generally, thought disorders. These are people with disorganized thinking. Their thoughts may be blocked, meaning they don't have the ability to properly think through answers and provide answers. All sorts of problems that suggest that the person does not have the wherewithal to focus and refocus and look at evidence and assist their counsel and answer questions. Very, very serious issues. Some clients also have, and this is a major issue in schizophrenia, something called negative symptoms. Positive symptoms in schizophrenia are noted by hallucinations and delusions generally. Negative symptoms are associated with disruptions to normal emotions and behaviors. These symptoms are harder to recognize as part of the disorder, but they can be mistaken for depression and even other conditions. Negative symptoms include people who they just lack pleasure in their everyday life. They have no sense of purpose, it seems. They lack the ability to begin and to sustain planned activities. They may speak very little. They may have a very flat affect like this and may not offer any affective involvement. They may not smile or respond to jokes or even basic communications between two people, even in the privacy of your office where they feel secure with the person. They may need help with everyday tasks. They often neglect personal hygiene. They may seem lazy or unwilling to help themselves, but really the problem is that they have these negative symptoms, often in the context of schizophrenia. This is another important issue. If the client repeatedly is unable to help themselves, they don't come to your office, they miss appointments, if the client doesn't seem to want to answer questions, they're self-sabotaging, they seem to be undermining their own best interests in some way or another, those are huge red flags for competency issues that could be very helpful in the context of immigration court. And although I've mentioned it before, cognitive symptoms, clients who have poor executive functioning, they don't have the ability to understand information and to use that information to make decisions. They may have trouble focusing and paying attention. They may have problems with working memory. That is the ability to use information immediately after learning it. And cognitive symptoms may make it hard to lead a normal life and to even earn a living. The other thing about cognitive symptoms are it can cause a lot of emotional distress. So a person with very serious cognitive issues, and perhaps even because of not just schizophrenia, but an elderly person due to dementia or Alzheimer's, they may be emotionally distressed by their frustration with themselves, given their inability to properly focus and process information and so on. Another major area where there could be psychosis, of course, is bipolar disorder, where there's mania with expansive energy. The person may be very goal-directed with pressured speech and racing thoughts and grandiosity. And the person may suffer from other periods of deep depression and even psychosis. Some clients may also have ADHD or present with ADHD. This is obviously clients with inattention, hyperactivity, and impulsivity. It's thought to be, because it's diagnosed often as a childhood problem where you pop a pill and then you're okay, ADHD is a very serious disorder potentially, and it may really prohibit a person, an adult, from properly focusing on their immigration case in a way that would show that they're not competent to answer questions or assist their lawyer in immigration court. I've said this before, but I'll say it again. So many clients you're seeing have had PTSD because of their experiences in their country of origin, and it's crucial to understand that. I just want to give you a few caveats. A client may have suffered a single incident that can be systemically damaging. That is, you see a lot of clients with trauma cases, obviously, as immigration defense lawyers, and they've suffered repeated harms in their country of origin that result in PTSD because of human rights violations or whatnot. But a client can have a single incident of harm that can be systemically damaging. And, I'll give you an example. My grandfather of blessed memory was in this terrible car accident when he was in his 40s, and he never got in the car again. He never drove again. He was a successful businessman who came here as an immigrant. Why? Because he grew up suffering terrible harm in his country of origin, persecution in Eastern Europe, and this potentially life-threatening car accident was such that even though it was a single incident, he never had any other car accidents, he never got in the car again. So it's important to understand that a client who suffers a single incident of harm in their country of origin may be sufficiently traumatized that they're not able to participate and to work with you in a case. You have also clients who suffer microaggressions that can add up systemically to damaging harms. I see this all the time, particularly women, quite frankly, who have had, husbands in their country of origin who were alcoholics. And, the woman will say, well, I wasn't physically abused. I don't think I was really emotionally or psychologically abused. But when you listen to the woman's narrative that over a period of years, the person suffered multiple microaggressions that add up to systemically damaging harm. Another area is depression. We don't think of it as something that could prohibit the person from properly advocating and working and looking at, evidence and cross-examination issues in immigration court. But depression can be completely debilitating. This is particularly true if the person has thoughts of suicide. That occurs where a person feels profound psychological pain and deep feelings of helplessness and hopelessness. Many of these people just want to sleep and sleep so they never wake up, so their psychological pain will vanish. You'd be surprised how many people suffer from either active or passive suicidal ideation, and that should also be asked about. Many clients, because they have very limited educations and in their country of origin they didn't have proper nutrition, they may have suffered from improper developmental milestones, meaning maybe their mom gave birth to them when they were 6, 8, 10 weeks early. Maybe they didn't have proper nutrition. Maybe they didn't have proper care. I've had clients who tell me that their parents worked 7 days a week, 10 hours a day trying to survive in their country of origin, so they didn't have proper caretakers. That also adds to improper development. Clients who don't read or write, even though they attended grade 6, 7, or 8 in their country of origin. Clients who perhaps don't have the ability to function. All these suggest perhaps intellectual disabilities, particularly if you have a client that has very limited insight and very poor judgment. We talked about cognitive issues, but again, any client with poor memory, disorientation, clients that can't process information or retain or learn new information, this is a very important issue because you may have a very clear narrative of your immigration issue, but when you're working with your immigration lawyer, you may have to retain or learn new issue in order to properly not just present the information in immigration court, but be able to answer questions that are asked to you from either the government attorney or from the immigration judge. It's very important to look at functioning. That is not just the person's diagnosis, which of course is relevant, but look at the person's overall functioning. Is this a person that can take care of themselves? They have good, self-care. They have good self-advocacy. Is this a person that perhaps cumulatively taken together all their issues just could not in any meaningful way present in immigration court in a way that is reasonable? So to look at not just functioning, but patterns of behavior, patterns of functioning. You also may want to look at people that present in atypical ways. Just because a person doesn't present with a diagnosis even after having seen a physician, it doesn't mean they don't have subclinical or atypical issues. We see this all the time. A person may not have diabetes, they may have pre-diabetes because their levels are such that it doesn't count as clinical, but it doesn't mean that they don't have serious health issues, so they really have to monitor their diet, they really have to monitor their food intake, they have to exercise and so on. Similarly, a person may not have, a psychiatric diagnosis, but the psychological injuries and challenges and traumas that they've suffered over years or decades taken together is such that it may really impair their ability to function or to answer questions in immigration court and so on. Sometimes lawyers ask, although rarely, about factitious disorder and malingering, and I just want to distinguish them for you. Malingering occurs where someone feigns or fakes symptoms for pecuniary gain. In other words, you walk in front of a car and you purposely suffer a small amount of damage, bodily damage, and you go to a lawyer to sue and so on. You've basically caused those injuries to yourself, or you fake injuries for another reason. Maybe you want workman's compensation or something. That's malingering. But there's something called factitious disorder, which is an actual psychiatric disorder. And that occurs when a person acts as if he or she has an illness by deliberately producing feigning or exaggerating symptoms. Why? Because the person needs psychological care. They need emotional support. They're ashamed of it. They can't articulate it. For whatever reason, they can't talk about it. They can't present in that way. And so they present with these fake issues in order to gain that support. If it's imposed on somebody else, it could be very serious, such as when an adult takes a child to the emergency room. The adult says, oh, this child has symptoms X, Y, and Z. The child does not have those symptoms. The child does not complain of those symptoms. It's by proxy. The adult needs the support in one way or another. The adult is bringing the child to the emergency room as a by proxy. Many of our clients, as I said, are ignorant about their mental health issues. They've come from societies where they don't have the resources. They may not have financial resources in the United States to attend to them. They may fear authority. They may feel that their symptoms are overwhelming, so they can't adequately work with their attorney. They may say that they're okay and work with their attorney. When they get to immigration court, the reality of the seriousness of their symptoms becomes apparent, and they cannot answer questions or adequately provide a narrative of their experiences in their country of origin. And they may really be very traumatized to the point that what they're presenting is a very inadequate picture of what they may have presented in a very coherent way in their lawyer's office. Well, that's the presentation today. I really want to stress again the crucial importance of competency as a consideration for your client, given that our clients have so often come from places where they've suffered all sorts of trauma and problems for all sorts of reasons. Matter of MAM, I think, is really underused. I have not read all the progeny from Matter of MAM, but it's really important to take a look at some of that case law. And, also to remember, as I said at the beginning, it's not competency like we learned in immigration, in law school about criminal cases, and competency in the context of a criminal court. The competency criteria, and as it's understood for immigration court, is completely different with completely different criteria. The last thing I would say is don't think about psychiatric problems and mental health problems when it comes to competency. Think about the client in a humanistic way. Is this client able to relate information? Is this client able to function? Is this client able to answer question? Is this client going to be sufficiently calm that he or she can consider and reflect on questions being asked and to assist their attorney? That, to me, is the core of Matter of MAM. Please don't hesitate to email me. I'll send you a redacted copy of a Matter of MAM competency case sample. Email me if you want to refer me any cases. I'd be happy to speak with you. You can always call. Usually email's best. Again, if you email me, put in the subject line what the issue is so I know it's a real email and not spam. I hope this was helpful, and I certainly hope that you continue to listen to this series of programs. I've done, as I said, thousands of these for CLEs throughout the United States, and I hope this was beneficial to you. Thank you, and have a good day.